Hi everyone, my name is Nicole Howe and welcome to the third part of our employment law webinar series. Today we're going to be focusing on termination, adverse action and redundancy under the Fair Work Act. Specifically, we're going to look at the possible claims employees may make following an employer-initiated termination and what steps you need to take as an employer to minimise any successful claims. The reality is, by having an understanding of the potential claims, you can effectively manage the termination to minimise the risk of a successful claim. So specifically today we're going to examine a few key areas. We're going to look at notice of termination and we'll also take into consideration what happens when a contract specifies a longer notice period than what is outlined in the National Employment Standards. We'll look at the minimum employment period under the Fair Work Act. This is often referred to by many people as the probation period. We'll have a look at terminating an employee on the grounds of poor performance and what factors you need to consider. We'll also look at terminating an employee on the grounds of serious misconduct, which is treated a little bit differently, particularly in regards to the notice period required. We'll have a look at adverse action claims under the Act. What does adverse action mean and what you need to be aware of? And lastly, we'll look at unfair dismissal and unlawful termination claims and the difference between the two, finishing off with redundancy and what you need to know when it's considered a redundancy and what steps that you need to take as an employer. So who am I? My name's Nicole Howe. I'm the Managing Consultant with Liquid HR. If you've listened to other parts of our webinar series, you would already be quite familiar with me and my background, but I have a HR generalist background and spent some time specialising in industrial relations and particularly working with employers to support them with any claims that were made after a termination. So let's start off by looking at notice of termination. So notice of termination is covered in the National Employment Standards and it's based on an employee's length of service. So as you can see in the table here, if an employee has less than 1 year, they get 1 week's notice, more than 1 year but less than 3 years, 2 weeks, more than 3 years service but less than 5 years is 3 weeks, and more than 5 years is 4 weeks. If the employee is over the age of 45 and they have at least 2 years service with you, they actually receive an additional week's notice if you do terminate them. It's important to note that it's not a requirement for them to provide you with that additional week's notice. So we covered notice of termination in the National Employment Standards in our last webinar session. What we would like to discuss today is whether or not you can have a longer notice period in a contract. So it's common for many contracts to specify a notice period of 4 weeks after the employee has completed their probationary period. This is fine, however, you need to be aware that you will not be able to withhold money owing to the employee, so for example from their final pay or their annual leave payout, upon termination if they do not provide the notice in their contract. This can only be done when the employee fails to provide the appropriate notice under the National Employment Standards. So if you do have a 4-week notice period in a contract of employment, regardless of the employee's length of service, and the employee only has 1 year's service, you could lodge a breach of contract claim. However, often the cost associated with this is higher than the benefit that you would receive. So looking at the minimum employment period, the minimum employment period under the Fair Work Act is what most of you would refer to as a probationary period. Essentially, it means the same thing, however, the probationary period is the language that was used under old legislation. All full-time and part-time employees you engage are subject to a minimum employment period. If you have less than 15 employees in your business, the minimum employment period is 12 months. If you have 15 or more employees, the minimum employment period is 6 months. So this period is an opportunity for both parties to assess suitability. If you do decide to terminate an employee in their minimum employment period for performance concerns, they're not able to make an unfair dismissal claim. After the employee has completed their minimum employment period, They can make a claim if they feel they have been unfairly dismissed. So we'll touch on this in a little bit more detail later. So it's really important to specify minimum employment periods in a contract of employment and review an employee's performance prior to their end of the minimum employment period. So you can't go a day over. It actually goes up to this, if you're an employer with 15 or more employees, it will go up to the 6-month anniversary to the day. So let's look at termination in regards to performance. So sometimes an employee you recruit does not meet the performance expectations for the role. The approach you take in this situation will often depend on if the employee has completed their minimum employment period or not. So if the employee has not completed their minimum employment period, no formal warnings are required. You can meet with the employee and advise you will be terminating their employment as they are not meeting the required performance standards, ensuring you provide the appropriate notice of termination. So either the notice in the National Employment Standards or the notice which is specified in the contract of employment, whichever is higher. I think it's really important to comment here that we do not recommend terminating the employee without providing them with an opportunity to improve. Starting a new role can be daunting and employees can sometimes take a little bit of time to settle in. How you support the employee during their first 6 months can have a profound impact on their success. So you should ensure you provide appropriate training and give them regular feedback, focusing on what they're doing well, but also being really transparent if they're not getting something right and giving them the opportunity to improve. If, after you're comfortable that you've done everything you can to support them and they are still not suitable, you should then consider termination. So, a point here, organisations who recruit people quickly and turn over new team members quickly often have difficulty establishing a strong organisational culture based on trust and high performance. Remember, all the other people in your business observe how you treat each employee. However, if the employee is outside their minimum employment period, there are certain steps that you need to take. Firstly, it's really important to clarify the 3 warning process that many people often refer to is not legally required. Whilst the 3 warning process will help you to meet some of the requirements, you could terminate an employee after 2 warnings. So to terminate an employee based on performance, you need to be able to show that the dismissal was not harsh, unjust, or unreasonable. So to do this, you need to show firstly that there was a valid reason for the dismissal related to the person's capacity or conduct. You need to show that the employee was notified of the reason. You need to show that the employee was given an opportunity to respond to any concerns that you had regarding their capacity or their conduct, and that you considered that response. You need to allow the employee to have a support person present at any meeting. So that support person could be another colleague, a family member. Sometimes employees wish to have the union represent them. You need to be able to show that the employee had been warned about the unsatisfactory performance or conduct and given the opportunity to improve. So as such, it's not enough to terminate an employee without any warning. If you have performance concerns, you should start by inviting the employee to a formal meeting and give them the opportunity to have a support person present. In this meeting, you should outline the concerns that you have, providing specific examples. Then give the employee the opportunity to respond. You then need to show consideration to the employee's response before determining the outcome. So we suggest that you end the meeting and hold a follow-up meeting later that day or the next day with the outcome. The outcome may be a verbal warning, which you should still document on the employee's file, or a written warning. The employee should be provided with a copy of this warning, and you should work on a performance improvement plan to get the employee back on track. What's really important here is that you set up a follow-up meeting, so approximately 4 weeks later, to see how the employee is progressing. Otherwise, it can easily be forgotten about, and then you try and pick it up later on, and there's been no consistency in the performance management process. So you then need to follow the same process in the follow-up meeting. Your next step may be a second and final warning or a second written warning. Remember, the whole idea of a performance management process is to get the employee back on track, not steps to proceed to termination. If the employee continues to not meet expectations despite warnings, coaching and support, then you may consider termination as a final option. If you are a small business, so that's defined as a business with less than 15 employees, the Fair Work Commission has what's referred to as a Small Business Fair Dismissal Code. And the code outlines the steps you need to take prior to terminating an employee. So you should always refer to this checklist prior to any termination. It can also be helpful as a starting point for larger employers. However, keep in mind that the Commission is likely to have higher expectations of larger employers, particularly if they have in-house HR. Termination for serious misconduct. Let's look next at adverse action. So, under the Fair Work Act, an employee can make what is referred to as a general protections claim. They would do this if they believe that they have been adversely affected by a decision made because of their workplace rights or because they possessed a discriminatory attribute. So, an example here would be, let's say, a casual employee making a claim that their shifts have been reduced as they're a union delegate. These claims are quite significant as the legislation is so broad and it possesses a number of risks for employers. The claims can be made not only by current employees but also by contractors. There's no minimum period that an employee needs to work to be able to make an adverse action claim. In addition to this, there are more remedies available to employees, including uncapped damages to the employee. With adverse action, the onus of proof is reversed. This means that the employer is considered guilty until proven otherwise. As an employer, it's important to be aware that these claims can be made and that you take all the appropriate steps to ensure that you do not make any decisions that discriminate against the employee if they have a workplace right. Unfair dismissal. So an employee can make an unfair dismissal claim if they believe their termination has been harsh, unjust, or unreasonable. There are a few minimum requirements that must be met for a claim to be considered. Firstly, the employee must have completed their minimum employment period that we covered off on earlier. The employee must lodge the claim within 21 days of the date of their termination. The employee must be a full-time or part-time employee or a casual employee employed on a regular and systematic basis with an ongoing expectation of employment. If the employee does meet these requirements, the Fair Work Commission will notify the employer, so usually via email, of the claim. You'll then have a time period to respond, and you must respond using a particular form. The matter is then listed for conciliation. The first step of conciliation is usually held over the phone, where a Fair Work Commission conciliator will dial in both parties, so the employer and the employee. And the purpose of the conciliation is not to go through all of the facts, but to see if both parties can come to a resolution to settle the matter. If an agreement is made, the Commission then develops an agreement which is signed by both parties. If the matter cannot be settled at conciliation, then the case will proceed to a conference or hearing before a Commission member at the Fair Work Commission. All facts will be considered and a determination will be made. If the decision is in favour of the employee, there's a few different remedies that the employee can receive. The first and primary remedy is reinstatement into the employee's previous role, or compensation up to 6 months' wages. Whilst reinstatement is the primary remedy, it is rare, and often compensation is given instead. The important takeaway here is to be proactive. Understand your risks and take the steps to effectively manage an employee. So if you do need to proceed to determination, you could show that the dismissal was fair. Unlawful termination. So now you understand unfair dismissal, I'll tell you a little bit more about unlawful termination. An employee can make an unlawful termination claim if they feel they've been terminated on unlawful grounds. So a lot of unlawful termination claims are now covered by adverse action. There's a very small group of employees who have access to this. So this is if an employee believes that they have been terminated on discriminatory grounds. Looking at redundancy. So redundancy is when an employer's role is no longer required to be performed by anyone in the business. For a redundancy to be genuine, you need to be able to show there was a valid reason for the redundancy and you have complied with any consultation requirements in an award or an agreement. So it's really important to consult with any impacted employees and discuss their feedback. So sometimes what happens when you go through a redundancy process is that employees have alternative suggestions that you may not have even considered. So you also need to search for suitable alternative employment in the business, or if you have any related entities, you need to look for employment for that employee within those entities as well. Only once you've done this can you proceed with a redundancy. So the National Employment Standards, which we covered in a previous webinar, specifies an employee's entitlement to redundancy pay based on their length of service. The employee would also receive notice of termination, payment of any unused annual leave, and in certain states, pro rata long service leave or long service leave if they've become entitled to it. If an employee believes that their redundancy was not genuine, they may make an unfair dismissal claim. So thank you. That's a really brief overview of the common claims that are made under the Fair Work Act. If you do have any questions, please don't hesitate to reach out to us. That's what we're here for. Our contact details are on the slide, and I look forward to speaking to some of you soon.